I want to tell you about her before I tell you about the case. Because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. After I finished speaking that day, the room went so still I could hear the light above the clerk's desk buzzing. No one reached for a pen. No one shifted a chair. I remember that silence first, even now, because the law had finally said what it could say, and what it could say was still smaller than what had been taken. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right, to the right people. Subscribe before I keep going. Marisol Vega was 34 when she came into my courtroom. The first thing I noticed was not the wheelchair. It was the pause she made at the threshold, the small pause of someone who has learned not to trust a doorway until she has measured it with her eyes. People who have to live that way move through space differently. I recognized it at once. She wore a gray sweater even though the day was warm. She kept one hand flat on a blue folder in her lap whenever the lawyer spoke too long, not gripping it, just resting there, as if she was making sure the papers were still real. During a recess, she apologized to the court reporter for taking extra time to turn her chair in the aisle. I have not forgotten that, not because it was large, because it was true. Thomas Bell was the defendant. He owned the building through a small property company and managed most things himself. In court, he kept straightening one shirt cuff, then the other, as if order in fabric might help him if the facts would not. He looked at me. He looked at his lawyer. He looked past Marisol more than he looked at her. There was one moment when he seemed plainly human to me. He took out reading glasses before one photo was shown and his hand shook when he opened them. That mattered to me, and not in a way that helped him. It told me he was not numb. He was capable of seeing. He had simply made a habit of looking away when seeing might cost him something. The incident happened on Friday, October 11, 2024, at 7:18 p.m., outside 1816 Harlow Street in Dayton, Ohio. Marisol lived in apartment 1A. The building had 2 concrete steps at the front and no ramp. She had asked 3 times in writing for permission to install a removable aluminum ramp at the front door. A nonprofit had offered to pay for it. A licensed contractor had offered to install it. The request was simple, funded, and documented. Thomas Bell said no each time. In one email he said, "I am not turning my building into a hospital." In another he said, "You already have an entrance that works." Those words were read aloud in my courtroom. I did not need anyone to explain them to me. The so-called other entrance was through the back alley, a side gate, broken pavement, a service door with a raised lip. In light rain that evening, her right wheel slipped as she tried to clear that threshold. Her chair tipped back. She threw out her left hand to stop the fall. She tore a ligament in her wrist and damaged nerves at the base of her thumb. That injury mattered beyond the medical chart. For a wheelchair user, a hand is not just a hand. It is motion, balance, work, transfer, cooking, reaching, getting home. Surgery repaired some of it. Therapy helped some more. Full strength did not return. Subscribe. Not for me. For the reason I am telling this, some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. The case reached me the way these cases usually do. Not through tears first, through paper. A housing discrimination complaint, medical records, photographs of the front steps and the back alley, emails, a sketch of the proposed ramp, an invoice from the nonprofit that had offered to cover the cost. By the time I had finished the file, I knew the shape of the legal question. What stayed with me was the shape of the human one. Most people do not know the difference between a housing accommodation and a housing modification. I had to think about that distinction very carefully here. In plain language, an accommodation changes a rule. A modification changes the space itself. A ramp is a modification. A landlord can ask for safe plans and lawful installation. What a landlord cannot do is refuse because he does not like what disability will look like on his property. The page that made me stop was not a dramatic page. It was an email from the nonprofit offering full insurance coverage, city permit coordination, and no cost to the landlord for installation or removal if Marisol later moved out. Beneath that was Belle's reply, 2 sentences, 1 refusal, no counterproposal, no request for revised plans, no call to the city, no effort at all. I could order consequences, but I could not give her back the hand that pushed her chair. The morning of trial, I watched both of them enter from the bench. That view matters. From up there, you see things other people miss because you are the only one facing every face at once. Marisol came in first with her sister Anna. She checked the route from the door to council table, even in a courthouse built to meet access rules. Habit does not disappear just because one room is finally ready for you. Thomas Bell entered 6 minutes later. He did not look at Marisol, but I saw something almost no one else in that room was positioned to see. He turned once before sitting down to make sure his son was in the second row behind him. Then he faced forward. He was still a father in that moment. That did not soften the case for me. It deepened it. Ordinary people make choices with long shadows. There were 3 moments in that courtroom when the room went fully quiet. Not the kind of quiet that comes between questions, the kind that settles when something true has entered the room and nobody knows what to do with it yet. Those 3 silences are the spine of this story. The first came when Marisol testified. Her lawyer had walked her through dates, requests, photographs, invoices, weather reports, all the flat pieces of proof. She answered carefully. She never raised her voice. Then her lawyer asked why she had kept insisting on the front ramp when Mr. Bell said the back way was available. Marisol looked down at the blue folder in her lap and said, "I was not asking for a favor, I was asking for a way home." The room went still for 6 seconds. I know because the court reporter stopped moving, and my clerk looked up from her screen. It was not a strained silence. It was a recognition silence. Something had moved from argument to truth. When the silence broke, it was Bell's lawyer asking for a glass of water. After that, the evidence landed differently. We saw photographs of the front steps from 4 angles. We saw the back entrance after rain. We saw a tape measure against the metal lip of the service door. We saw Marisol's 3 written requests. We saw the nonprofit offer. We saw the denial. A maintenance worker named Gerald Pike testified after lunch. He had worked for Bell for 9 years. He did not look comfortable, but he did answer. He said he had suggested a temporary modular ramp in March. He said sections were already stored at another Bell property. Then he said, "We had enough aluminum on site to make the entrance usable by noon the next day." I wrote that down in my own hand. There was more. An occupational therapist explained what upper body strain means when your arms are also your mobility. A hand surgeon explained the tear and the nerve damage. Marisol's sister said there had been nights when Marisol sat in a ride car outside her own building waiting for someone strong enough to help lift and steady her. A receipt showed extra ride charges because the back drop-off took longer. None of it was loud. All of it was clear. Bell's lawyer was not careless. He argued what he had. He said the first ramp sketch may not have met the best slope standard. That was true. He said a city review might have been needed because the front entrance sat near a public sidewalk. That was also true. For a short time I paused there. A court should never punish someone for refusing an unsafe design just because a safe one might have existed. But the pause ended because Thomas Bell had done nothing with those concerns except use them. He did not ask for a revised plan. He did not call the city, he did not meet the installer, he did not offer a temporary fix, he did not say yes with conditions, he only said no. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now, and then let me keep going. Thomas Bell took the stand in a navy suit and spoke in the voice of a man trying to sound careful after being careless for too long. He said he had to think about all tenants. He said visible changes affect property value. He said insurance companies can be difficult. He said, "I felt sorry for her. I was trying to be fair to everyone." I wrote it down. I looked at it for a long time before I moved on to the next page. He believed that sentence helped him. What it told me instead was that he had placed her access on the same level as everybody else's comfort, and called that fairness. He had made her entry into her own home one preference among many. That is a quiet kind of wrong. It still leaves damage behind. His lawyer tried to widen the frame. He pointed out that Bell had allowed a shower grab bar in another unit. He pointed out that Bell had waived one late fee after Marisol's surgery. He pointed out that Bell had a daughter with asthma and therefore understood that health can shape a household. I listened to each point. I considered each point. People are rarely only one thing, and law becomes lazy when it forgets that. The problem was not that Thomas Bell had no capacity for kindness. The problem was that he kept that kindness for moments that cost him almost nothing, then withheld action at the exact point where law and decency required something real. A waived fee does not make a doorway usable. A kind tone does not lower a step. Then came the part that fixed the case in my mind, beyond revision. Bell's lawyer asked why he had not at least met Marisol at the building after her first request. Bell said, "I did not think it was urgent yet." He said it quietly, and still wrong. Urgency tells you a great deal about power. The person who does not have to solve the problem is often the person who decides how long it can remain a problem without counting. Before the second silence, Marisol was recalled for a short rebuttal. Bell's lawyer asked whether she could have moved. She said yes, if she had broken her lease, paid moving costs she did not have, found another unit she could enter, and rebuilt her whole support system after surgery. Then she said, "When people tell you to move, what they often mean is disappear." That line did not create the second silence. It prepared the room for it. I need to place one memory beside this case before I go on. Years before I ever sat on this bench, I watched my mother help my grandfather into my aunt's house after his stroke. My uncle had built a short plywood ramp that afternoon. The wood was still pale from the saw. The grass smelled freshly cut. My mother stood at the bottom with one hand out, even after my grandfather was already safely inside. Not because he needed it right then, because she wanted him to see the hand was there if he did. I still remember the hollow sound the wheels made on that unfinished wood. Then I returned to my courtroom. The second silence came at the end of Thomas Bell's testimony. His lawyer asked if there was anything else he wanted the court to understand. Bell looked at me, then at Marisol for the first time that day, and said, "I never meant for her to get hurt." That was his last sentence. The room went quiet for 11 seconds. It was not the same quiet as before. The first silence opened the room. This one closed it. The first was recognition. The second was consequence. In that silence, the room understood that he still believed injury was the real event, and refusal was only the lead-up. I understood that his moral timeline began far too late. Subscribe before I go further. I have more to tell. And the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. By closing arguments, the case had narrowed into one plain line. A tenant using a wheelchair asked for a lawful way through her own front door. She brought plans. She brought funding. She brought time. Her landlord refused because he did not want the building to look different. He offered the back alley. The back alley caused the fall. I made the decision carefully. I made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. Then I said the verdict. I found Thomas Bell and Bell Residential Holdings liable for unlawful disability discrimination, refusal of a reasonable modification, and reckless disregard that directly led to bodily injury. I said those legal words first because the law has to name what happened before it can answer it. Then I moved to the sentence. I said, "Mr. Bell, I am ordering you and Bell Residential Holdings to pay $185,000. I broke that number into parts. $60,000 to Marisol Vega for documented medical costs, lost income, and pain tied to the injury. $50,000 for future occupational therapy, adaptive supports, and transportation during recovery. $75,000 to the Montgomery County Independent Living Access Fund because harm should answer, where it can, to the kind of harm it helped create." Then I said, I am also ordering Bell Residential Holdings barred from signing any new residential lease in this county for 18 months, effective at 5 p.m. today, unless and until a court-approved access audit is completed at every current property. I wanted that time said out loud. Specific time matters. It prevents slow obedience disguised as confusion. I explained why in plain terms. I said I was not taking homes away from current tenants. I was stopping fresh profit from flowing through a business that had shown such poor judgment about who gets to enter a home safely. If the company could not manage one doorway lawfully, it had no claim to easy trust on others. Then I said, I am ordering Mr. Bell to complete 300 hours of supervised service with Openway Dayton and the Montgomery Mobility Resource Center within 12 months. Not generic hours, not any place that would sign a paper and send him home. I named the placement because the sentence needed to force contact with the reality he had kept at a distance. I told him service is not redemption by itself, it is contact. Sometimes contact is where understanding begins, though it should not have to begin there. Then I said, within 30 days you will install at 1816 Harlow Street a code-compliant front entry ramp, a weather-safe landing, a threshold transition, and an automatic door opener, all at your expense, all inspected by an independent accessibility specialist appointed by this court. That was the restorative part. I would not answer her request with money alone. I added one more requirement because the harm had not been only private. I said, within 45 days you will stand before the Dayton Rental Housing Board and read aloud a written statement approved by this court acknowledging that your refusal of lawful access led to injury. You will mail that same statement to every current tenant and every property your company owns in this county. You will post it in each main entrance for 90 days, and you will adopt, file, and permanently maintain a written accessibility modification policy for all present and future tenants. That policy requirement is what reached past Marisol's case, not a slogan, not a promise, a filed policy, enforceable, reviewable, lasting beyond the news of one trial. Subscribe. I will say it plainly. I owe it to her to keep telling this story. You subscribing is how her story reaches past this video. Subscribe and stay. Then I spoke directly to Thomas Bell. I said, what you did was not simply refuse a ramp. You refused the front of her own life. You took an ordinary act and turned it into a daily negotiation with weather, pain, and other people's availability. The cost can be measured in surgery, therapy, lost work, and fear. The harder cost is that you taught her to expect resistance at her own door. I said one sentence for his family because they were there too. I said, to the people who love you, I am not speaking accusation, and I am not offering comfort. I am saying only that one person's choices rarely stay with one person. Then I said, your position required stewardship. It required lawful care over property other people trusted with their bodies and their routines and their ordinary returning. You chose appearance over entry. I let that sit for a moment. Then I ended where I believed the court had to end. I said, Ms. Vega should never have had to ask this many times to be allowed home. That was when Silence 3 arrived completely. It lasted 14 seconds. From the bench, silence is physical. I heard the air unit click on near the back wall. I heard someone crease a paper cup in the gallery. Bell's lawyer had one hand on the table and did not lift it. Marisol's sister covered her mouth. Marisol herself stayed very still. Then the silence broke because Marisol let out one breath and turned her chair slightly toward the aisle. That was all. I did not need more than that. As the courtroom emptied, I remained on the bench. The first person I watched closely was Anna, her sister. She did not go to the lawyers. She went straight to the left side of Marisol's chair and checked the wheel lock with 2 quick fingers, the way care becomes muscle memory after enough time. Then Marisol said to her, quiet but clear enough for me to hear, I can stop apologizing for the door now. That is the sentence I have said back to myself more than once since the case closed. The appeal was filed 21 days later. It went to the Ohio 2nd District Court of Appeals. The process took 14 months. The panel affirmed my order in full and said in plain language that a landlord cannot hide behind delay, appearance concerns, or alternate inconvenience when a tenant has made a clear, practical, lawful request for access. When I read that ruling, I closed the file, set my hand on the cover for a moment, and then went on with the rest of my day. That is the honest response. After enough years on the bench, even the cases that stay with you still have to share a calendar with everything else. On September 18, 2025, at 9:12 that morning, a compliance photograph was emailed to my chambers as part of the final inspection record. It showed the front of 1816 Harlow Street after the work was done. Aluminum ramp, dark grip surface, new landing, door opener plate beside the frame. In the lower left corner, not posed and not looking at the camera, Marisol was coming through the front with a paper grocery bag on her lap. There are other people I want to speak for, other cases where someone needed a voice in that room and what they received instead was procedure. Subscribe and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. What this case left me with was not a simple lesson, it left me with a question. At what point does repeated refusal stop sounding like caution and start telling the truth about whose hardship we are willing to treat as normal? I still do not know the full answer. I only know that this case sharpened the question until I could no longer set it aside. If you know something of Marisol's experience, then you may know the feeling I recognized in her face before she ever testified. It is not fear exactly. It is not shame exactly. It is the feeling of having to present your own need in a form that other people will find acceptable before they will admit it is real. I saw it in her pause at the doorway. I saw it when she apologized for taking time she had every right to use. If that feeling is familiar to you, then I want to say something exact. The fact that you learned to explain yourself carefully does not mean the burden was yours to carry. If you are more like Thomas Bell, or if you have power over doors, desks, schedules, approvals, budgets, or property, then I have one question I wanted to ask him from the bench and could not because it was not a legal question. Here it is. When did convenience start sounding so much like reason to you? Ask yourself that before the next request reaches your hands. Do not wait for a court order to teach you the size of someone else's ordinary life. Marisol, that is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. If you speak in the comments, speak as if you are standing in a courthouse hallway after the door has opened, and you know the person beside you has also seen something that should not be forgotten.